Welcome, everyone. Glad to be with you today. We've got a very interesting topic in mind. And I'll tell you, as we started planning our year with events and topics and webinars, reviewing buy-sell planning was not on the top of our list. A lot of the techniques in this space have been pretty well done and dusted for years and years from our point of view. That is until on June 6th of 2024, the Supreme Court threw us all a curveball, and we ended up with a pretty titanic shift in the way that all of this is working. In that decision, the long and short of it, and we'll get into more detail here as we talk today. The long and short of it, though, is that the Connelly family ended up owing almost $900,000 in estate taxes without acquiring 1 cent of additional wealth, just based on a change in interpretation on the way that the value of life insurance death benefits relate to an entity purchase buy-sell agreement for business value purposes. And so big surprise for this family, totally out of left field for them. As we go through today, hopefully from their surprise, you'll learn a few things that you need to be aware of, review with your advisor team to be able to avoid the same kind of pitfalls there. Last thing I think any of our families want, or any of us want for our families, I should say, is for us to put them in a situation where they end up owing taxes without actually getting anything additional for it. I'm your host today, Austin Bransgrove. I'm part of the team here at Rethink Wealth. We work with business owners across the country as it relates to issues around business value, growth, benefits plans, deferred compensation agreements, corporate structure, coordinating with accounting teams on tax planning, estate planning, all the way to comprehensive exit planning. And as we start today, we're going to begin with just a basic framework and understanding of what has been the historical lay of the land. What have the options been generally as it relates to buy-sell planning, so that you can understand where are we, where were we, what's changed, and then what do you need to do about it from here, right? So that's our goal as we work through today, help you understand that context and have a list of a handful of things. What do you need to do about it from here? Historically, we've had 3 options for buy-sell planning. Left to right, we've got cross-purchase agreements, entity purchase agreements, and a special purpose or insurance-only LLC. Sometimes you'll hear it called one or two of those things. The basics of a cross-purchase is that if I'm in business with someone, I commit, I say, hey, if you die, I'm going to buy your shares from your estate. If I die, you're going to buy my shares from my estate. That way, my existing business partner is the one who gets to retain the value of the company, continue moving forward. If something happens and I pass away, or I lose a license, or there's bankruptcy, or I become disabled, all kinds of events can trigger that cross purchase. The point in question in the Connelly case is specifically that someone died. So that's kind of the context. And as I talk today, I'm going to reference death a lot, but buy-sells can be triggered for a number of different types of reasons, just depending on the specific business. In an entity purchase agreement, we have that same kind of relationship, but now our buyer is the business, where instead of my business partner committing that they're going to buy from me and I'm going to buy from them, now the business is going to redeem my ownership. So that can be a stock redemption, that can be an entity purchase. Both of those mean essentially the same thing. It's just that not every company has stock if you think about an LLC or a partnership. But essentially, I pass away. Now my ownership interest is redeemed. It is purchased by the business, and the remaining owners, whether there's 2, 3, 4, 5 of them, all of them are able to now step into their proportional ownership of what was mine to begin with. A special LLC or an insurance-only LLC essentially turns what was just a entity or a cross purchase into some of the simplicity of an entity purchase, right? And what I want you to think through is this: in a cross purchase agreement, say that someone dies. Well, now if there's 5 owners, we have four different parties buying that one deceased owner's interest. If there's three owners, then the two survivors are buying the interest, so forth and so on. Well, with a special LLC, we start to pick up some simplicities so that we don't have to have four or five, six, however many owners there are. We don't have to have all these different life insurance policies on this person. I'll give you an example and try to clarify this. So imagine we've got four owners. Well, now me as one of the four owners, my first partner, my second partner, my third partner all need to own a life insurance policy on me relative to the value of the business, how much I own, and how much they own, right? So if we all own 25% for parties, then each of them would own the exact same amount of insurance on my life to buy that 25%. Okay, so if the company's worth $12 million, my 25% is worth $3 million. Partner one, partner two, partner three each own a $1 million life insurance policy on me. And then we do the same thing in reverse. So partner two and three and me, we all own that on partner one, so forth and so on. And what you end up with is a lot of life insurance policies. So three partners, you have to have six life insurance policies. For four partners, we need 12. For five partners, we need 20. And it becomes pretty onerous, which is why anything beyond two partners, historically, we've looked at that entity purchase as the mechanism. But an entity purchase isn't always ideal because it's different from a tax standpoint and things like that. We knew it was different even before the Connelly case. That's why this special LLC was created, so that we have this other partnership. Its only job is to own life insurance, and we get to have one policy per partner and then still affect the terms of the cross purchase buy sell if somebody passes away. There's a whole lot of literature on this. We've even done more topics on this. As we'll talk about today, even the efficacy of the special LLC, we've got more questions about after this Connelly decision in June. So we're not going to spend a whole lot more time talking about it. If you're leaving this session saying, I don't really get that, I don't really understand, that's okay. Again, reach out to our team. We're happy to help unpack what makes sense, what doesn't make sense. When would we still want to consider that, if at all, in light of the changes? So with that basic understanding, we get that essentially either my partners or the business are going to have this obligation to buy the company from my heirs if I pass away. That's the bones, the nuts and bolts there of a buy-sell agreement. And you want it to be binding typically so that you're not going to have someone who's completely unqualified to be operating in business also now serving as an owner of a company that may be in distress because one of their owners just died. Okay. Well, what happened here in the Connelly case was that two brothers, Thomas and Michael, had structured their buy-sell with an option for each of them to buy, but an obligation for the business to redeem the shares at the end of the day. And so Michael owns 77% of the business, Thomas owns 23%, and it was set up here as this entity purchase, the stock redemption plan. You can see that right there on the screen on the top right. And so what happened going into this was that their company, Crown Sea Supply, purchased life insurance policies both on Michael and on Thomas to be able to redeem the value of the business, right? This $3.9 billion company. And when Michael passed away a number of years ago, more than a decade ago at this point, what happened was $3 million of life insurance came into the company as a death benefit and was used to redeem the $3 million worth of stock from Michael's estate. Okay, you can see that blue arrow moving up, that death benefit coming in, the cash going to Michael's heirs so that his family then, through the terms of his will and his estate planning, were able to have cash there. The stock was redeemed to the company, which left Thomas as the 100% owner of the business. Pretty straightforward. all things considered, right? This is the simplicity of this is one of the reasons why these agreements have been used so much, especially as you start to have 3 or 4 or 5 different owners, which we commonly see in a number of different kind of specialty professional practices with doctors, with sometimes legacy family businesses, sometimes with law firms, accounting firms, things like that. And the surprise here was that the Supreme Court indicated not only was the value of the business not $3 million, but also the 3.9, but also the $3 million stock redemption there on the right-hand side, it did not offset the value of the $3 million death benefit. Okay, so let me add a little bit more color to this. For years, we've all understood that the value of life insurance is real value. When somebody dies, that death benefit coming in is actual money that is included in the value of their overall assets in the context of a business. We all know that is actual money that's included in the overall book value of the business. And so any appraiser would include that there. What was new with the Supreme Court's analysis was this understanding that this obligation to buy back the stock did not reduce dollar for dollar the amount of death benefit that it came in. And in fact, it had no impact whatsoever. So instead of the business being worth about $3.9 million, it was worth $6.9 million. And it completely changed the landscape for the rest of the Connelly family. And in fact, that value for Thomas, for his estate tax filing when he passed away, it was not his 77% portion of $3 million. It ended up being a $5.3 million value for estate tax purposes, and it kicked him into the estate tax threshold. So up until this value was applied, his estate had filed a return saying he owed no estate taxes, and really just documents that allowed his surviving family to kind of carry over and use exemptions in the future based on the Internal Revenue Code. Well, what the IRS found is they reviewed the return was that the values were incorrect. That value of his stock was not 3 million, it was 5.3 million. And that added more than $2 million of value. It kicked him into an estate tax landscape. And so at a 40% rate, this new value of assets was taxed, and overnight, without one penny of additional money received in their hands, the estate owed $899,914 in unexpected tax. No additional money, just almost $1 million in tax. Now you can imagine that his family was surprised. His advisors were probably surprised. And so they spent over a decade fighting the US government in court on this. And they took it through the local circuits, they took it to Court of Appeals, they took it all the way to the Supreme Court over a period of over a decade. And the Supreme Court held that the IRS was correct, all of the calculations correct, and the family owed this tax bill, totally unexpectedly. That alone, massive issue, right? The knowing that you're going to end up in a situation, or you could end up, I should say, in a situation like this family did, where you're not expecting any tax, and now there's almost $1 million in tax. What's become really clear for us as professionals in this space is that a lot of questions arise, right? Not just what are the estate tax ramifications, but also if the value of the business are higher, what does that do for the tax basis for the estate? I'll give some more examples on that in a minute. Is there a capital loss that the estate is filing because the value of the buy-sell is different than the value of the actual amount for estate tax purposes, according to the IRS with this new guidance. What's become very clear is that the entity purchase buy sell is probably one of the least optimal ways for most owners to structure their agreements based on the potential income tax and potential estate tax issues in play. You can see small kind of misunderstanding like the Connelly family had can have relatively devastating consequences, a very large tax bill. Let's look at another example here with a hypothetical. So in this example, we've got Jack and Jill, who own Big Trucks Construction, right? Hypothetical case, hypothetical business. And the same kind of scenario, we have this $10 million business, and Jack's ownership, if it's redeemed in this entity purchase, would have been redeemed for $5 million, right? Half of 10 is 5 million. And so, this is the lay of the land. However, what we know is that based on the estate tax issues in play from Connelly, the company is not worth $10 million for estate taxes, it's worth 15. And Jack's share of the 15 at a 50-50 ownership would have been $7.5 million. What does that mean? Well, the estate is going to receive this basis adjustment for $7.5 million, right? Some of y'all may have heard that phrase before, step up in basis. Technical term here is that it's called a basis adjustment. You can actually have a step down as well if something's worth less than what it was paid for. But this value that was going to be 5 as long as Jack was alive, now all of a sudden, because the life insurance is in the company, is worth 7.5. Well, how does the executor handle this $2.5 million capital loss, right? Because, and think through it this way, the cash received is 5, the value was 7.5. Technically, the estate lost $2.5 million doing this buy sell. What happens? And the reality is, there's not a lot of consensus yet among professionals about what happens here. This is an untested issue, but one of those additional wrinkles. And this is the type of thing that will affect businesses, even if your company is small enough or your overall wealth is low enough that you don't otherwise face estate tax issues. Simply having an entity purchase agreement at all is going to expose your estate to these questions of what happens. Is there a loss? How is that handled? How is this made whole? And it's a big deal because an executor has a fiduciary obligation to your heirs to receive the full value of all of the assets in play. If there's a $2.5 million spread here between the amount that they received and the actual value, according to the IRS, have they breached their duty? A lot of questions start to come up without a lot of good answers. And again, we face this reality where we probably won't know for a number of years until people start to pass away. These things start to occur, and the IRS begins to scrutinize income tax and estate tax returns as people pass and as these situations come up. And so the question for many business owners is going to be, do you want to learn what the issue is, or do you want your family to learn what the issue is after you've passed away and after it's all over by becoming a court case with the IRS, the same way, unfortunately, that the Connelly family did in their situation with their business. And so if you're like me, you start to read through and just a bit of understanding about some of these issues that are in play, and you say, well, geez, like this sounds really bad. What on earth do I do about it? And I'll tell you, our team for a number of weeks here has been wrestling with those same issues in preparation for getting some information, some analysis, some next steps out to all of you to be able to respond with. And so what we've come down to, what we've really understood so far, is that there's probably at least 4 viable potential paths forward. First and foremost, I think that generally speaking, we can go through and think about using cross purchase agreements in lieu of entity purchase agreements. Um, so if you reflect back to that picture, that means that we're going to have relationships, these agreements and between our owners. So owner one, owner two, owner three, even if there's 4 or 5 owners, it's probably a simpler, less treacherous path to have 4 or 5 owners engage in a cross purchase agreement with each other rather than enter into the big unknown of how these basis issues and what the estate tax ramifications are going to be using an entity purchase agreement. Now, maybe you already have an entity purchase agreement. You may be looking at this saying, oh, well, okay, well, how do we change that? What do we do? That is a treacherous path in and of itself. The IRS provides all kinds of restrictions inside the tax code about who you can transfer life insurance policies to without creating taxes. And we've written on this to some degree. We've got some articles up about this that we're happy to send over to you. If you shoot us an email, scan the QR code, we can get that information to you. But essentially, unless I'm a partner in a partnership, not a stock company, but a partnership, or unless I'm the insured on the life insurance policy, I can't just receive someone else's policy without there being what's called a transfer for value. And so it's not necessarily turnkey. It's not necessarily simple in a lot of situations to turn what was entity purchase into cross purchase. This is one of those areas where you're going to need professional help along the way to make sure that you don't end up triggering some issues and creating taxation, income taxation of all of the death benefit on a life insurance policy. It's a whole other minefield on top of what is already a complicated situation in light of Connelly. So that's number one. Think about what's possible. How can we create a cross purchase agreement instead of an entity purchase agreement? If you already have an entity purchase agreement, this is again where you want to partner with professionals and make sure that as you make changes, if you make changes, you've really followed all of the steps to avoid triggering income taxation of millions of dollars worth of death benefit. Number two, think about moving key person policies on the owner of a business to be outside of the company, right? So a lot of times we'll end up working with not just business owners, but also their families. And what we found works really well in this situation is to just have that key person policy that maybe is required for financing or a loan or as collateral for some kind of contract that can just be owned by the individual. That can just be owned by their family in some way or in other kinds of techniques instead of being owned by the business. And now maybe we still have to think about some estate tax planning, but we've avoided those potential income tax issues related to the basis of the business if that owner passes away. And these things do happen. We've seen owners pass. We've seen owners end up in the ICU. These things happen every year. We have a handful of people go through, unfortunately, these situations. We want to make sure if there's key person policies in place that they're not going to go and create income tax problems for you related to basis, or artificially inflate the value of the business in some way that's going to be damaging for the buy sell. The third potential path we've thought through is if it's just too much, if it's a bridge too far to tackle all of the issues, maybe not every owner, maybe not all of your business partners care, then each of you individually can always think about how do you cover your own estate tax planning. And so for a long time, using different life insurance strategies have been really successful in terms of creating funding for potential taxes that are due. You can think about it kind of as a gross up. So if you were going to owe $1 million in tax, what's possible there to have $1 million of life insurance outside of your estate so that your family has that cash ready to go, ready to fund the tax bill that the IRS is going to say that you owe. And lastly, and I think this last one is most interesting and most valuable for someone who already has an estate tax issue, an estate tax concern, is maybe think about some combination techniques. That insurance only LLC, that special purpose LLC, both the same thing that we talked about at the very beginning of the discussion here today. It may still have exposure to these basis issues. It may still have exposure with these estate tax issues. There's actually some conflict here among expert opinions in the buy sell space about what those ramifications are going to be. So again, if you don't want your family to be a court case, we'll say, great, let's just not use those strategies. If you're willing to take some risks here and there, maybe these are things that are worthwhile. And I think where it's probably worth the most is that if we already have estate taxes, maybe it's possible to think about these combination strategies where we create cross-purchase funding. We use different trusts for the benefit of your family. We use these partnerships to own different life insurance policies, and these relatively sophisticated techniques to create a cross purchase for the estate tax purposes and hopefully avoid any of those basis issues that could come up. I think certainly we avoid them as it relates to the operating business. Maybe we avoid them. Maybe we get out from that as it relates to the insurance LLC, but much less of a concern there than the operating company itself. So you can see, even as I run down those four, not the simplest thing. It's not necessarily turnkey where you say, okay, great, well, we're going to write down this and this and this, and then we're fine. These are techniques that require experienced counsel, experienced help as you're moving through this process. So as we're talking through, you may say, yeah, that's a lot of pieces. There's a lot of potential pitfalls there. How do I go about this? What do I do? Take a moment here, scan this QR code. I'm about to switch the page. You can scan the next one too. And just fill out this request for an initial consultation, an initial meeting. We will be happy to provide this complimentary initial discussion and talk through what the lay of the land is, what the options could be, so that you start to understand, what does it mean for you? What does it mean for your family? What does it mean for your business? And so that review really, it looks like this, that we'll have this initial complimentary consultation. One of the services that our team provides on a regular basis is to look at business continuity planning and really do this full buy-sell gap analysis. What would you get for that as we're looking at these things? Well, first and foremost, we and a team of professionals that we work with really closely will perform a full document review and analysis. So we've got some bullet points to take back to your attorney and really talk about, this is what we see, these are the pitfalls, and strategize collectively as your advice team what that next step is going to be. Second, we'll look at what are all of the things that currently exist for your existing insurance policies. How are they owned? Do we have any issues related to that potential transfer for value where the death benefit could become income taxable if the wrong things are done? How can those existing policies be maintained and be used so that you're not just starting from scratch as you're thinking about all of these plans and thinking about all of this change? We'll look at all of those review and provide an analysis there. Third, we'll look at what's the current approximate value of the company. Our team uses tools on a regular basis called Biz Equity, which often can give us a pretty good high-level view of what's the value of the business, what are the KPIs that are happening, and it'll be a good measuring stick to identify, do you already have a gap versus how your buy-sell is written, how the value is listed there, relative to what that company may be worth on the open market to another buyer. We'll take a look comprehensively at what, if any, estate tax exposure you may have. These are rules that are in flux. They've been in flux for forever. 25 years ago, if we think back to 2000, 2001, the estate tax exemption was $1 million. You had over $1 million worth of assets. You were in that world where you could be paying estate taxes. In 2010, there was no exemption. And by that, I mean there was no estate tax at all. Anyone who died in 2010, there was nothing to do, nothing to worry about. In 2011, it moved to $5 million. In 2017, it adjusted to double these numbers adjusted for inflation. Well, we see changes coming down the pike again, always at the whims of Congress. But if nothing changes in the law, current record high exemptions are going to cut in half in 2026. And so we want to think through what's your exposure today? What's your exposure based on the way that your buy-sell agreement is structured? Is there any additional tax that you may be subjected to, your family may be subjected to, based on how the buy-sell works? That's avoidable in some way. A lot of times those estate taxes are optional taxes for families who haven't gone through and done planning for it. Take a look at, is that the case for your family? What are the options there? And what do we see? Finally, looking at this executive summary total of all of these moving pieces, you can get the sense that there's a lot of details involved in each of these steps, each of these components. The estate tax issues, the income tax issues are but one of many things that we often find as gaps as we go through and we look at these buy-sell agreements. And we'll look at what are the recommendations, what are the core options for your specific situation, for your specific business partners, for your family, and what are the next steps to go through and take care of that. If you're thinking through all this stuff is super complicated, all this stuff is hopefully not going to be a problem for a really long time, but going to be really expensive if it does show up and it's not addressed, this kind of program, this kind of review is absolutely for you. So take a second, scan that QR code again. That'll take you right to a link to book on our calendar and set up that initial complimentary consultation so we can start to unpack together what are the options. What do we see? Is this full analysis something that would be helpful for you? And if so, then we'll work through and help you down that road together. I hope that as we've gone through this summary today, it's been eye-opening in a lot of ways. You may be feeling right now that it is a little bit scary, that's a little bit unknown, that you're not really sure what to do about it or how to think about it. If that's the case, totally understand. Again, that's that point where I'd invite you, reach out to the person who invited you to join this session. Use those QR codes, which I'll pull up one more time just so you can take one more snapshot of it. And we will be happy to help you go through and figure out, how do we take the complicated and boil it down into simple, actionable steps that you and your family can take care of and you and your business partners can take care of to avoid ending up in the news the way that the Connelly family did with just a couple of missteps that ended up being incredibly expensive overall. So thanks a bunch for joining. Looking forward to those next conversations and those next discussions one-on-one here with y'all. We're happy to send over any other links to articles and resources that we have posted. Again, reach back out to the person who invited you here today, and we'll get those in your hands. Hope you have an awesome day, and look forward to speaking with you soon. Take care.